Okay, a very good evening to all of you, and I'm recording this lecture now, so we have to know that we are being captured. A very good evening to all of you once again. So tonight we would like to discuss the initiating factor we call Duress and Undue influence. Duress and Undue influence. So first of all, we will try and understand what it is, what are the remedies for it, and then what is undue influence. And once again, I will encourage you to still read Mrs. Donna Hammond's treatments, which is a very good treatment. So chapter 10 of Donna Hammond's work. Duress and undue influence. And as I've told you before, I like that work for the reason that it enables us to get the Ghanaian cases as well. Good. We have already noted the point that we have already noted the point that if you are going to have a contract, there should be genuine consent, meaning that the parties must have exchanged their consent freely and genuinely. Nobody should have been deceived into giving the consent, and nobody should have been intimidated or threatened in giving consent. So the consent should be voluntary and it should be quite free. And we have seen how certain factors would actually affect validity of this consent. Mistake, we discussed mistake not too long ago, and we have also just discussed misrepresentation. And now we want to discuss duress and undue influence as it were. And it's a very straightforward, we are not going to waste a lot of time on it. Yeah, so when we say duress, what is it? The actual or threatened violence to or restraint of the person of a contracting party. So where actual violence, maybe somebody decided to give you a big slap, sign it. You are slapped and then you sign. Or the situation in which I am, I cannot stop. So when I finish, I'll do it for you, okay? Or if you have more, I'll finish, I'll leave you at 9. Yeah, so where someone has actually brought some kind of force against you before you consented, then there could be a case of a duress. Or where we don't have actual violence, but the threat of violence. Just like maybe the ransom type of, or the kidnapping. You are kidnapped or somebody close to you is kidnapped, and then they bring documents for you to sign before they will release the person and all that. So that is also another form of what? The violence we are talking about. So, in other words, duress is when a person is compelled or coerced to enter into a contract by the use of force, physical compulsion, or through threats of bodily harm or harm to a property. So sometimes it may not just be a threat to only your person, but also your property as well. Okay, if you don't agree, you're going to blow up your house. You're going to deflate your tires and things like that. All these are some form of what? Physical compulsion. So it is overcoming of the free will of the party to enter into a contract by causing fear in that party. Consent is supposed to be voluntary. It's supposed to be free. But where you were pushed to say yes, then that yes is not genuine. So that is what we are talking about. Where a contract is made through duress, or where duress can be established, then the contract is not void, it is voidable. And at this stage, who is still not clear concerning the distinction between void and voidable? Good. You are my friend because you are honest. And you know something? What is your name, please? Percy. Good. I used to have a one mate called Percy Kumar. So, Percy, you alone, you are excused from the burden of writing the distinction between voidable and void contract. So, all the rest, you have to write it. So, all the rest, you have to write it. Please, you have to write it. No, you have to write it. What is the difference between void and voidable contracts? I'm giving you 1 minute. Those of you who are online, you can also put your response in the chat. The difference between void and voidable contracts. Okay, so some of you were able to tell us what a void contract is and what a voidable contract is. So simply, a void contract is a nullity, isn't it? A nullity in the sense that it does not create any legal right or obligation. And since it's a nullity, we don't even talk about enforceability. Because the thing is non-est, it's void. Just like a null set. A voidable contract, and of course, some also added void ab initio. So void ab initio means that right from the moment that the contract was taught, so those who are online are challenging those who are physically here. Let's look at some of the responses. Lodina, voidable contracts are contracts which can be set aside by party, whereas void contracts are those that are null. Okay. Lantern, Dorothy, voidable contracts one that may be true. That parties may choose to enforce or not to choose. To obey the void contracts one which is invalid from the start. They don't feasible at all. Why a voidable contracts one that can be avoided? But subject to certain that as third party right. Okay, so the point is voidable contracts is valid for the time being. It's not valid completely, or it's binding for the time being, let's put it that way. But it can be set aside or repudiated or rescinded at the instance or at the option of an aggrieved party, a party affected by some vitiating factor. A void contract is void, it's nullity. You don't need to take any step to render it invalid. So that is one thing we should note. Yeah, so Duress renders a contract voidable at the option of a party whose consent was obtained under the duress. So if you look at the case of Barton and Armstrong, a very old case. Armstrong was the chairman and Barton the managing director of an insurance company. Armstrong threatened to have Barton killed if he did not sign an agreement to buy out Armstrong's interest in the company on very favorable terms. And eventually, when he came before the Privy Council on an appeal, the board of Privy Council held that the agreement was signed under duress and could be avoided by what? So here, there was a threatened violence, isn't it? What was the threatened violence? That, yeah, you'll be killed. Yeah, so if he even agreed to sign it, he signed it and is it not freely? He didn't sign it freely. Now, for a long time, the common law doctrine of duress was limited only to violence and threat of violence to the person. But in the 70s, the court demonstrated that it is not only threat to violence or violence to the person, but also if someone threatens to undermine or breach economic interests, that can also be a duress. So if you look at the case of North Ocean Shipping Company Limited against Undue Construction Company Limited, the defendants were shipbuilders. They agreed to build a tanker for the claimant ship owners. And the price was payable in the US dollars in 5 installments. After the first installment had been paid, there was a sharp fall in the value of the US dollar. And the defendants threatened to break the contract unless the plaintiff paid extra 10% on each of the remaining installments. The plaintiff had already entered into a lucrative contract to charter the tanker on its completion. And anxious to take delivery, they reluctantly paid the increased installment because they didn't want to miss out on being able to fulfill the lucrative contract. 8 months later, they brought an action to recover the excess over the original contract price. That's very similar to DLC builders against race. Remember that? Remember DLC builders against race? Very sure. Clap for yourself. Okay. Yeah, so the court held that the contract was voidable on grounds of economic duress, but that the plaintiff could not recover the because they had affirmed the contract by failing to protest before they did. And in fact, I would say that a case which we need to read, in addition to North Ocean Company, is the case of Power On against La Yulong. Power On against La Yulong. The spelling, you have it in that, yeah. The spelling is here. Power On against La Yulong. Try and read the full judgment, because if you read the full judgment of the Power On, you will notice that the entire law on duress has been neatly discussed by Lord Scammon, and that is why you need to read that. You know, there are certain cases, you read it, and indirectly you are reading other cases as well, because they are all discussed over there. And even this Barton and Armstrong, you meet it in a part